set. Please be seated.
Good morning.
Good morning.
Welcome to the First District Court of Appeals. Today we just have one argument, and that is in Re DB, case number C240076, 77 and 78. And for the appellant, we have Ms. Kane.
Yes, good morning, Your Honor.
Good morning. And for the appellee, we have Mr. Wessels.
Correct.
Good morning.
Good morning, Your Honor.
All right, Ms. Kane, would you like to reserve some rebuttal time?
Yes, 3 minutes, please.
Okay, I'll keep your time. When you have a minute left of your initial time, the yellow light will come on. Red means you're out of time.
Good morning, Your Honors. Margaret Kane on behalf of the appellant, DB. May it please the court. Innocent until proven guilty beyond a reasonable doubt. Beyond a reasonable doubt. In overturning the magistrate's decision to acquit and instead adjudicating DB on these charges, the juvenile court judge abandoned this fundamental principle of our criminal legal system. Not only did the evidence introduced in this case fail to establish the identity of the shooter, but the state's primary piece of evidence should have never been admitted in the first instance. The state's case against DB hinges primarily on a short compilation of 5 surveillance videos collected from 4 different locations. These videos were spliced together into a very short compilation video that purports to establish a timeline of events. Notably, however, the state only called one witness, Officer Yanko, to authenticate 4 out of the 5 videos. Officer Yanko was not qualified to authenticate. Under Ohio law, there are 2 theories of admissibility for video and photographic evidence. The first theory is called the pictorial testimony theory. The second, the silent witness theory. Officer Yanko was not qualified to authenticate the video under the pictorial testimony theory because he was not present at the scene when the incident occurred. The pictorial testimony theory.
Counsel, was he competent to authenticate the places in the video? So, for example, would he have been able to say, I've been to this BP, I've been to this McDonald's, this is the real BP depicted in the video?
So he could identify the places in the video. However, this court recently handled this situation when it came up in State v. Rashid. In State v. Rashid, a video was introduced. The witness was able to identify not only the restaurant in which the video was taken, but also the defendant in the video. However, because she was not present at the time that the incident captured in the video occurred, this court found that she was unable to authenticate the video despite being able to identify the location from which the video was taken.
No, wait, in that case, though, there was, remind me, there was no police officer who testified that the officer went and retrieved the video, right?
Correct.
Okay.
And so this court,
That's different.
right, so that was under the pictorial testimony theory that this court analyzed the issue of being able to recognize the specific location captured in the video.
But you have here, though, you have a police officer who testified that he went to the location, worked with these businesses before, right?
Mm-hmm.
I guess they would give him video for other investigations, especially the BP, I think, and did the transferring himself onto like a USB drive, right?
So he did testify that he went to the locations and inserted his USB into the port at BP. And so the primary theory under which the state tried to have this video authenticated is under the silent witness theory. The silent witness theory contemplates authentication under 901B9, which requires that the individual who's called to authenticate has personal knowledge of the specific system that created the video And generally speaking, that is referring to the custodian of the system that produced it, so that the person who's testifying to authenticate can speak to the reliability of the system. And so in this instance, the police officer did go to these locations and ask an employee, for the BP at least, to pull a certain time and date, and downloaded that onto the USB. However, in Midland, which is the central case in which the Ohio Supreme Court defined what is required under these different theories of admissibility, the Ohio Supreme Court talked quite extensively about what is required in order to authenticate under the silent witness theory. Under the silent witness theory, you need to have somebody who has, so in that case, it was the custodian of the record who had watched in real time as the events unfolded. He was present in the control room. He understood where the cameras were located. He was able to testify to that. He was able to testify to the fact that there was no way that he was aware of that the video could be altered. And that is distinct from this case. So while the officer did go and collect these videos in person, he was not the custodian of the record. His knowledge was limited to how to access it via communicating with the individual who was the custodian of the record. And I will note that that was only for 1 of 5 videos, or 2 of 5 videos. That was for the VP, that he testified more specifically. Regarding the video that he obtained from Washland and McDonald's, there was even less specificity in the officer's testimony about the process.
Let me ask you though, are you saying it's only the custodian that can authenticate these videos, or could there be a situation where a police officer could do that?
I think that there is a situation where an officer could, through the process of their work, gain an adequate amount of knowledge of the system, but there would have to be really specific knowledge of the system in order to be able to authenticate. So for example, in this case, the officer noted that there was a discrepancy in the timestamps. None of the timestamps of the 5 videos lined up with one another, but he wasn't able to speak to why it was that the timestamps were off or to what extent they were off.
Well, does that go to admissibility?
So that goes to manifest weight in terms of the differences in the timestamps, but it also goes to the importance of why you need to have the correct person come to authenticate the video. So someone who was more familiar with the system, for example, in the case name is escaping me, but there was one case in which the property manager of an apartment complex came, Pickens, State v. Pickens. The property manager came to testify, and the property manager was able to explain why the timestamps from the various videos collected around the complex were different. And then the police officer who collected those videos from that complex had gone through very specific steps to identify where those discrepancies were and how many minutes. So for example, one video was 10 minutes delayed, another video was 5 minutes fast. The officer had gone through specific steps.
Are you saying that if the state couldn't put on somebody to explain why there was a timestamp discrepancy, that the videos would then be inadmissible?
Not necessarily, but I do think that you need somebody with more particularized knowledge of the surveillance system. The officer didn't testify to how the information was typically stored, whether it was recorded continuously, didn't testify to whether or not there had been any issues with the system in the past, whether there was any reason to believe that someone else could have accessed the video. And so while going to a location to obtain the video is a step, it is not enough to authenticate. But regardless, even if this court were to find that the video in this case these videos were properly authenticated, Nonetheless, this court should reverse and discharge because the videos, even if admitted, do not establish the identity of the shooter in this case,
So,
as the
Counsel,
magistrate found.
there's a fundamental problem with the videos, and I think it cuts at both of the issues that you've raised. The Washland video, you've pointed out that the timestamps don't add up, and based on my review, I concur with that. But the Washland video, which is the one that actually depicts a shooting, the timestamp is a full minute before the BP and the bus video. And so if the Washland video is accurate from a timing perspective, DB was still on the bus at that time.
That's correct. Yes.
What do we do with that information? Because the state didn't present any evidence to explain which particular set of videos was accurate in terms of the timing of the video or their sequence.
Right. So I think that necessitates reversal and discharge because the state did not prove beyond a reasonable doubt that the timeline that they claim was the chronological order of events actually was that. There was no testimony to explain how exactly those timestamps line up with what the actual timeline was. So for example, we don't know exactly what time this incident occurred. And so we don't have a base point from which we can look at these videos and say this was an accurate chronological ordering of the videos.
And does that go to the sufficiency and weight question or to the admissibility question or both?
It goes to both. I would say that it leans more towards the sufficiency and manifest weight issue. However, I think that it highlights the importance of having the correct people to authenticate the videos. And I will say, as a matter of policy, this court has done in the past a much better job, I think, than other district courts of maintaining a distinction between the two theories of admissibility. And I think that is crucial to ensure that videos that are being admitted are accurate and that they are evidence that is reliable, especially in the era of deepfakes in which we currently live. But I will also, kind of to your point about sufficiency and manifest weight in the videos, the video on which the state relies to claim that DB was the shooter is a video that the figure crossing the street is nearly imperceptible. You cannot tell age, race, gender, clothing, weight. There's one muzzle flash, but there's no evidence anywhere in the record to suggest that DB possessed a gun before, during, or after this incident. There's no fingerprints. There was no gun residue. There was no ballistics done to explain how a gunshot from that location would have hit the vehicle, although obviously the vehicle was hit. But the point is that the state's primary piece of evidence is this sequence of videos where none of the times line up. The videos are overlaid on top of each other. The Metro video, for example, during the interview with DB.
And you are a little bit beyond your initial time.
Oh,
If
thank
you want to
you.
reserve.
Yes, I'd like to reserve the remaining time. We would just ask for reversal and discharge of these offenses.
Good morning,
Good morning.
opposing counsel. I want to get immediately to a question, or to, I guess, a proposition that you raised, Judge Krause, about whether or not the defense is the juvenile is asking whether this court should promulgate a rule that, as a rule, officers are unqualified to testify to admissibility in this case. And it doesn't sound necessarily like that's where they're going for oral argument today, but as I read their brief, I mean, it seems as though they're trying to get some sort of rule that would espouse that only a custodian of the records is qualified to reach admissibility,
Well,
which
couldn't the officer have conducted a fuller investigation when he was on the scene of these businesses to inquire about these surveillance systems, I mean, he could have asked to see where the equipment was located, and he could have looked at how it was operating so that he could have provided fuller testimony.
And I think what Your Honor is getting to is a disagreement that I have with counsel when it comes to the exact knowledge that this particular officer had. I think that the testimony establishes that he did have direct working knowledge. I mean, he says specifically, and I did go through and pull his testimony with regards to the different locations that he visited. With regards to the BP location, he says he went to location. He says he went to the machine, reviewed the video on the machine, and put it onto a USB itself. He says that with regard to BP, that he explains what the machine is. He says it's a DVR machine. He describes, although there's an indiscernible part in the transcripts, he begins to talk about the type of software, not just the hardware that the system uses, and talks about how it can archive videos back in time. When asked by the prosecutor whether he's been there before, he says, I've been there numerous times, and I have a working relationship with the people there, and I have a working relationship with this knowledge because I go there so often. It's my understanding that Yanko was sent there in order, because he specifically has a knowledge of these systems and is able to go in and get directly what he needs. That's why he was sent there. With regards to that's with regards to the BP again. He says that there was a DVR box that is their guide. He talks about running the system, exporting specifically a certain date and time frame for all of the cameras from the BP location. With regard to Washland, again, when he's asked about how he got it, he says it's a very similar process. He talks about going to the location, himself physically using a USB to pull the information from the video. And he talks about the procedures and the time frame that he uses to identify the location and to take those videos from Washland.
But with respect to the Washland system in particular, does he offer any testimony that describes where the cameras are placed or how the system creates the surveillance videos?
I don't believe he offers any testimony to that fact, but where I think the standard for admissibility relies on, simply reaching a reasonable likelihood that the information is authentic. That's what this is really about, whether the videos that he's pulled are what they say they are. I believe his testimony was sufficient to establish that he had the working knowledge, the information in order to testify to that specifically.
And let me ask you this question as well. Let's say we were to agree with you that the state met the evidentiary standard with respect to the BP video, but not with the Washland video. What does that do with respect to the overall compilation video?
I'd have to go back and look specifically at the Washland. I know that I endeavored in my brief to try and separate those, and I think it's somewhat clear from the transcript. I think if the court were to determine that the Washland video would be inadmissible, they would have to try and take that out and look at what evidence still stands in terms of, for example, the weight and sufficiency challenge.
Is that the shooting? The Washland video is the...
It does.
Okay, so that's the main...
It's the one that includes the muzzle flash
Yeah.
on it, so at least I'd have to look back. I know that there's a moment in time where as the state has said, as the juvenile is crossing Warsaw Avenue, that I think is shown on both the Washland video and the BP video. But obviously, even if that muzzle flash is not shown, there's still the bullet hole in the car that has to connect. It's not as if that eliminates the possibility of there being a fire. Obviously, there was a firearm that was fired. To speak to something that you asked, Judge Kinsley, specifically when it went to the weight and sufficiency of the evidence, whether or not there is a way to know outside of this video who the person was who was shown in that Warsaw video. I'll say two things. One, the trial court said that State's Exhibit 1 shows what she called an unbroken chain of events chronologically from one event to the other. In addition to that, we also have testimony from the juvenile himself saying, I crossed Warsaw to get away from these people who he said had pulled into the parking lot. And the video, I think, clearly shows there was only one person who was crossing Warsaw Avenue. That's both in the BP video and in the Washland video. And so
What do you do with the time difference, though?
Well, I think the time difference and I think ultimately that goes more towards the weight of the evidence than it does to the admissibility. With relation to the distinction in the time frames, the officer does testify as to the difference between in his attempts in order to allow them to line up chronologically. And when I say chronologically, I mean as the events were happening, not necessarily just what the numbers show. That would have to be a determination for the trier of fact. And I think that actually goes to the officer's ability and his knowledge of the systems itself. For example, with the McDonald's video, when asked about why isn't there a time frame that's listed in that video, he says specifically, well, the way that the system works is that it actually has a time frame, but when it's exported using the process that I use to export it, it gets rid of the timestamp.
So the trier of fact would have to disregard the timestamps and just somehow, I mean, when the judge is talking about defining characteristics and continuity, what are we talking about? Just because it's hard to see on the video.
Right.
So what's the defining characteristics that we're
Of the individual who crossed the street, or I
Yeah,
guess I'm
just,
confused as
well,
to-
I'm just trying to figure out, I found the video very hard to see, and apparently the officer who watched it many, many times offered an opinion that it was DB, and the magistrate disagreed with that, couldn't tell anything, and then the judge said, no, I can see that it's him. So I'm just, what are we looking for in this video that is such a defining characteristic?
Well, I think what the trial court relied on is the officer's testimony that there was that unbroken chain, that at least as I review the video, and obviously the court will have to do it for itself, from what I am witnessing, I'm witnessing the individual get off the bus and then following along with the officer's testimony of where that individual is positioned, what they're wearing when they get off the bus, and align with the testimony that he testified to, identifying which road is Warsaw Avenue and crossing that road, still wearing the same outfit that he was. There's a point where the two individuals split off, and I think the splitting off of DB crossing Warsaw Avenue aligns with not just what he testified to, but with what the video shows.
Can we
Ultimately,
see the split off on the video that has the muzzle flash? Because that's where, I just saw somebody crossing the street in a muzzle flash, but I don't know. I found it very hard to follow.
I believe that you can. I'd have to. I mean, it's been a while since I've reviewed them,
Yeah.
so I'd have to go back and review. But I do think that you are able to see it. I believe it's on the Washland and the BP video that this split happens, which is what the officer used to kind of combine those two, essentially saying, because you can see DB leaving the BP, crossing Warsaw on one of the BP surveillances, and you see that as well in the Washland video. That is one of the things that he's using to combine the two of them, or at least for the trier of fact to make that determination. Now, obviously, I think ultimately that goes down to when it comes to interpreting these videos, that I do believe that is for the trier of fact to determine when it comes to the weight and sufficiency arguments.
Interpreting the video?
For what the video shows, and when it comes to whether or not those two are connected in a way that is sufficient to find that unbroken chain of events. Ultimately, what I'll say is I guess to the first assignment of error, the judge specifically said that Officer Yanko offered sufficient knowledge and opinion to establish that the evidence was what it was purported to be. I think that's true given the testimony, given both the direct and circumstantial evidence in this case, and so I do think the video was properly authenticated and admitted.
Well, he wasn't there at the time of the shooting, right? So he couldn't authenticate that the events were what.
No, I don't think that under the pictorial method of authentication that Officer Yanko's testimony was used for that purpose. He was not there at the time when it happened, but as we know, there's multiple ways of authentication. I think that in addition to the testimony, I guess my point is that the additional testimony, in addition to what Yanko testified to, supports that those videos are what they purported to be, that they show the events from the night of the shooting in question, and they are taken from these establishments, and there's no other reason to think that they're unreliable for that purpose.
So that would be the silent witness pathway.
Correct.
All right.
And obviously, there is some overlap between the two of them in terms of, when the court has to make a decision about whether or not a a piece of evidence is authentic. There doesn't have to be just one theory. They can draw from both circumstantial and direct evidence to make that determination. But I do believe, at least as I read the testimony, that it seems as though the judge relied on the silent witness theory more than the pictorial testimony.
But we usually have cases where you have a police, because you cited many in your brief, where you have a police officer who pulls the video, but then you also have witnesses who actually witnessed the event. And in this particular case, we don't have any eyewitnesses to the event.
Right. I mean, we have the victims themselves testified when they were reviewing the parts of State's Exhibit 1 where their vehicle actually pulls into the BP, and they said that's what happened. That's us pulling into the BP, and they talk about their event. But there is not any. I don't believe there was any eyewitness that specifically said,
I saw this
that's him
person
coming
cross.
from the BP.
Right.
Correct. Although I will say, I mean, in terms of the weight and sufficiency argument, I agree with the court that viewing the video does show what the trial court found, which is that it shows DB getting off of the bus. I think his identity is clearly established at the beginning of where you can see his face. He's getting off the bus.
We said it was him. He admitted it was him, right?
Right.
Yeah.
Well, I guess, and some of this argument wraps around to, I believe that the videos support one another when it comes to this idea of whether or not, they show this unbroken time frame, or whether or not they're authenticated. That is to say that, you can establish going forward, that when he's shown in that, and he does say that it's him, but we also have officer testimony that, he's dealt with this individual before. That's him that's on the screen. Getting off, every step that aligns with this investigation, I think, is further supports the trial court's determination that the identity of the shooter was established at that time, and that it was DB who's the one who crossed the street in line with his testimony and fired the shot. And I do think the muzzle flash is clearly shown, and obviously we do have harm. Those were both elements that were found both by the magistrate and by the trial court in this case. Obviously, the thing that the two disagreed on was the identity of the shooter, but ultimately the juvenile court is the one who's the ultimate trier of fact, the one who reviews all of the evidence and makes that determination. I don't believe I have anything else unless there are any questions from the court.
Oh, thank you.
Thank you.
Rebuttal?
So I just want to touch on a couple of issues that came up. Particularly, I want to focus on sufficiency and manifest weight. So even if the videos properly came in to evidence in this case, the testimony regarding identity of the shooter is insufficient to establish that DB was the shooter. Yes, DB is visible on the bus, but the next videos do not establish his identity. At BP, you cannot see any defining characteristics. One officer, Officer Yanko, testified that he determined that the person who crossed the street was DB based on following his shoes. And Officer Yanko testified that his shoes were black and that he followed the figure's shoes, and that's how he determined that the person who got off the bus and the person who crossed the street was DB. Later, the next day at trial, Officer Conley testified, and he identified the person who crossed the street as DB because he also followed shoes, except for he testified that the shoes were a light color, and that's how he distinguished. Notably, there were numerous people who were milling about the BP during this time. The video clips are extremely short. Warsaw is a massive street where people cross all the time, and there is absolutely no way to tell who crossed the street. You cannot identify any characteristics. The officer was not there. The officer did not know DB. The officer did not offer any testimony to establish something identifiable about the person who crossed the street that could allow this court or the trial court to determine conclusively that the person who crossed the street was DB. In State v. Short, the court talked a little bit about when identity can be established using video. And there are circumstances in which one's identity can be established in a video. However, in State v. Short, despite having a witness who was very familiar with the defendant in that case and testified that in watching the video, they knew it was the defendant because of what the defendant was wearing and also because of a specific gait that the person had, and also had heard the defendant talking about an intention to cause harm to a particular person. Despite all of that, the court determined that because the video was grainy, because the video was so unclear, that that level of testimony wasn't enough to establish identity in that case. We have even less here.
You are at your time if you want to
Okay.
wrap up.
Thank you very much. So we have, in this case, a situation in which the state failed to prove beyond a reasonable doubt that DB was the shooter. And so we ask this court to reverse his adjudications and discharge him. Thank you.
Thank you. Thank you both for your arguments this morning. The case is now submitted, and we will issue a timely decision. Have a good rest of your day.
The Court of Appeals for the Village District will have is now adjourned.